What if I told you that your green card, the very document you worked so hard to obtain, could be taken away in an instant, even if you followed every rule, paid your taxes on time, and built your entire life in America? There are 5 critical mistakes that could destroy everything you've worked for. And the scariest part, most people don't even realize they're making these mistakes until it's too late. Stay with me because what you're about to learn could be the difference between keeping your American dream alive and losing it all in a matter of weeks. I'm here to guide you through the complex world of immigration law, and today's topic is one of the most important we've ever covered. We're talking about permanent residents, visa holders, and legal immigrants who are doing everything right, or so they think, but are unknowingly standing on the edge of a cliff. The immigration landscape has transformed dramatically, and what might have been overlooked just a few years ago can now trigger immediate deportation proceedings. This isn't about fear-mongering. This is about arming you with the knowledge you need to protect yourself, your family, and your future in this country. By the end of this video, you'll understand exactly which actions and situations pose the greatest threat to your legal status. More importantly, you'll know precisely what steps to take to safeguard your position and avoid the devastating consequences that have already impacted thousands of immigrants this year alone. So, if you or someone you care about holds a green card, work visa, or any form of legal status in the United States, this information is absolutely essential. Let's dive in. The first major threat to your legal status involves serious criminal convictions, and this is where things get particularly complicated. The term you need to understand is aggravated felonies. Now, here's where it gets confusing and dangerous. An aggravated felony under immigration law doesn't necessarily mean it was classified as a felony by your state court. Yes, you heard that right. Your state might have charged you with a misdemeanor. You might have paid a small fine, served no jail time whatsoever, and walked away thinking the matter was settled. But under federal immigration law, that same offense could be classified as an aggravated felony, and that classification changes everything. The federal immigration system operates under its own set of rules, and these rules are often far more severe than what you'll encounter in your local criminal court. Offenses that fall into this dangerous category include theft, regardless of the amount stolen, fraud, even if it seems minor to you, assault, which can include situations where no physical injury occurred, any form of violent behavior, including threats or intimidation. The critical factor here isn't how much time you spent in jail or whether you spent any time behind bars at all. The federal system looks at the nature of the crime itself and makes its own determination about severity. Let me paint you a picture of how this plays out in real life. Imagine you're a green card holder who's been living in the United States for 15 years. You own a home. Your children were born here. You've built a successful career. One night you make a mistake. Maybe you get into an argument that turns physical. Maybe you're accused of taking something that doesn't belong to you. The local prosecutor offers you a deal, plead guilty to a misdemeanor, pay a fine, maybe complete some community service, and you can move on with your life. It seems like the smart choice. You want to put this behind you quickly. You don't want the expense and stress of a trial. So, you accept the plea deal, pay your fine, complete your community service, and assume the chapter is closed. But here's the nightmare scenario. Months later, maybe even years later, you apply to renew your green card, or you travel outside the United States and attempt to return, or immigration authorities conduct a random review of your file. Suddenly you receive a notice to appear before an immigration judge. That misdemeanor conviction you thought was behind you, immigration authorities have classified it as an aggravated felony. And once that happens, you're facing mandatory detention and almost certain deportation. There are very few defenses available. The judges have limited discretion. Your 15 years of lawful residence under your American children, your home, your career, none of it may be enough to save you. This is why the advice I'm about to give you is absolutely critical. If you are ever arrested, if you are ever charged with any crime, no matter how minor it seems, you need 2 attorneys, not 1. You need a criminal defense attorney who understands the charges you're facing in state court. But just as importantly, you need an immigration attorney who can analyze those charges through the lens of federal immigration law. These 2 attorneys need to work together before you accept any plea deal, before you make any statements, before you take any action whatsoever. A decision that seems insignificant in criminal court can be catastrophic under immigration law. Don't let a moment of crisis destroy decades of lawful presence in this country. The second major threat involves drug charges, and honestly, this is an area where the law shows almost no mercy. Many people operate under the assumption that minor drug offenses, particularly possession of small amounts, won't seriously impact their immigration status. This assumption is not just wrong, it's dangerously wrong. The reality is that drug convictions trigger some of the harshest consequences in all of immigration law. Let's be very specific. Possession of cocaine, regardless of the amount. Possession of heroin, even a trace amount. Possession of prescription medications that weren't prescribed to you, even if you're holding them for a friend or family member. Possession of methamphetamines, ecstasy, or virtually any other controlled substance. The amount doesn't matter. You could be caught with a single pill, a tiny residue in a bag, or a minuscule quantity in your pocket. Under immigration law, that's enough to initiate deportation proceedings. Now, there is one very narrow exception, and it applies only to marijuana. If you're charged with possession of marijuana and the amount is less than 30 grams and this is your first offense, there's a possibility you might avoid immigration consequences. But notice how many conditions have to line up perfectly for this exception to apply. And even then, different jurisdictions interpret this exception differently. Let's say you're arrested on drug charges. You hire an attorney. You work out an arrangement. Maybe the prosecutor agrees to dismiss the charges if you complete a drug treatment program. Maybe you're offered a diversion program where the charges will be erased from your record if you stay clean. You complete the program successfully. The charges are dismissed. Your criminal record shows no conviction. You assume you're in the clear. But immigration authorities don't always see it that way. If at any point during the criminal proceedings you admitted to possessing the drugs, even if no conviction resulted, immigration officials can use that admission against you. That's right. The admission of guilt alone, even without a conviction, can be grounds for deportation. This is why you need specialized immigration advice the moment you're facing drug charges. What you say, what you admit to, how your case is resolved, every single detail matters under immigration law in ways that aren't immediately obvious in criminal court. The third major threat involves family violence and domestic disputes. Any act of violence, any threatening behavior, any violation of a protective order involving someone in your household can trigger deportation proceedings. And the definition of household or family member is much broader than most people realize. It includes your spouse, ex-spouse, children, including stepchildren and adopted children, your live-in partner, your parents, or your in-laws who live with you. The type of conduct that can get you in trouble is also broader than you think. Physical altercations are the obvious example, but it also includes unlawful touching like grabbing someone's arm, verbal threats even without physical contact, violating restraining orders, even unintentionally. In many jurisdictions, domestic violence charges are prosecuted as misdemeanors. You may face no jail time. You might be offered counseling or anger management classes. But under federal immigration law, domestic violence offenses are treated with extreme severity. Even a misdemeanor domestic violence conviction can make you deportable, regardless of how minor the incident seems or how long ago it happened. Let me give you an example. You're in a relationship that ends badly. During an argument, someone calls the police. Maybe voices were raised. Maybe there was a push. You're arrested. A prosecutor offers you a deal. Plead guilty to a misdemeanor. Take a class. No jail time. You accept, but now you've been convicted of a deportable offense. Immigration authorities may flag that conviction during a green card renewal or naturalization application. And, unlike criminal courts, immigration judges have very limited flexibility. Your entire legal status could be on the line. Always consult an immigration attorney before accepting any plea deal in a domestic violence case. The fourth major threat is immigration fraud. Immigration fraud includes lying on immigration forms, using forged documents, fake marriages for status, misrepresenting facts during interviews. Even if the fraud happened decades ago, there is no statute of limitations. Immigration authorities can reopen your case at any time. If they determine you obtained your green card through fraud, they can revoke it and begin deportation. This applies to all immigration applications you've ever filed. Green cards, work permits, travel documents, family petitions. If there are any mistakes or falsehoods, you should consult an attorney now before issues arise. The fifth threat is failing to update your address. Green card holders are legally required to notify immigration within 10 calendar days of moving. While this may seem minor, failure to update your address can hurt you later. If you're ever investigated, It may be used to show a pattern of non-compliance or diminish your credibility. It's easy to do online and takes minutes. Don't overlook it. Let's talk broader enforcement. The pace of deportation has accelerated. Cases that used to take months now move fast. Judges are under pressure to clear backlogs. Minor infractions can now trigger immediate detention and removal. So, what can you do? Consult an immigration attorney immediately if you face any criminal charges. Be completely honest on all immigration forms. Always update your address within 10 days of moving. Maintain documentation of your life here. Taxes, school records, employment, leases, medical files. Stay informed about changes in immigration laws and priorities. Address any past mistakes on your record before you're in trouble. Treat your legal status as an ongoing responsibility. It's not a finish line. Your green card, your visa, your work permit, it's not permanent protection. Mistakes, even small ones, can result in immediate, irreversible consequences. But now you know what to avoid, how to protect yourself, and what steps to take. Stay informed, stay compliant, stay proactive. Your legal status is worth defending.